Welcome to Saltivation. The Saltivation Show is a podcast series featuring the leading voices in salt, where we talk about the issues and strategies to help you make sense of state and local tax. Thanks for coming back to part 2 of our conversation with Paul Williams, Senior Tax Correspondent at Law 360, where we continue talking about newsworthy issues in state and local tax. In talking about home rule lands, we've got Louisiana, the Halstead Bead case is ongoing and, has some issues arising out of home rules. What are some of the items related to Halstead Bead that you all are, watching and reporting on?
Sure. Well, there are a few. Certainly the case itself, which is currently on appeal before the Fifth Circuit. Federal judge had dismissed the Halstead Bead's challenge on the Tax Injunction Act grounds, saying that federal courts didn't have jurisdiction because, it involves a state tax issue. And so that's really the issue that's on appeal now, not so much the merits of whether or not Louisiana's decentralized local sales tax system, could potentially, impose undue burdens under Wayfair. The taxpayers made the case that, or at least argued that the Tax Injunction Act shouldn't apply here because they're challenging the burdens themselves, the alleged burdens themselves, instead of an actual tax assessment. So they think that's kind of an exception to the Tax Injunction Act. That's really where it's what's before the court now at the Fifth Circuit. And I don't think any briefs have been filed yet there on appeal. But kind of related to that, there was a constitutional amendment that Louisiana voters had rejected last year. It was close, I think it was 51-49 or 52-48, that they voted against, creating a single unified central sales tax collection system for both in-state and out-of-state businesses. Because right now, Louisiana does have their centralized remote seller commission for remote sellers to file through as one portal, and in-state businesses have to file with each parish in which they do business. And so after the voters rejected that amendment last year, there was an effort this year to get it on the ballot again. And, that the Halstead Bead case was filed, I think, just a few days after the constitutional amendment result from last year. And there was a push to get it on the ballot again this year, and it got all the way to the end. It just needed one final concurrence vote from the Louisiana House, and it didn't come up. And essentially, the local government groups there had some opposition to it throughout. They thought that they wanted it to say more that the single commission would handle the remittance of taxes instead of the collection. And the sponsors and proponents of the amendment said, well, collection is what this is all about. So there's a push and pull there as to, how much power the local governments wanted to retain for the local tax collection versus, what the sponsors thought that the state, may need to do is, some have argued to comply with Wayfair. It is interesting to note, though, in the Halstead Bead case that the complaint that Halstead Bead filed didn't actually mention the Remote Sellers Commission, at least not by name. And that was an argument that the parishes and the State Department of Revenue, which was also involved in the case, had made, that they already offer this centralized sales tax collection entity. And they've tried to reduce the burdens for remote sellers. I can tell you, counsel for Halstead Bead, Joseph Bishop Henchman from the National Taxpayers Union, I asked him about that in one of our stories, and he had said, well, centralized filing isn't everything. The commission still directs you to the individual parishes to figure out some of the local rules, and it doesn't do enough. But that is one element of the case, if the merits do get decided on, is, that Louisiana has the centralized collection effort in place. I guess, the question is it enough? But the Remote Sellers Commission has been, operational for a couple of years now, and it is collecting revenue for the state.
Yeah. Well, it'll be very interesting to see with our SET system in Colorado as well. Arizona's been very successful with the home rule cities being collected at the state level for more than 4 years. So clearly there's more money going out to them and being collected because it's state administered, even though some of the rules are different. And we have the same issue in Colorado where we'll have a common collection point and a registration point, but not a common sense of rules. They all have different rules. And that is problematic for us in Colorado for taxpayers to comply.
And that was also one thing that some of the local government groups that we talked to, this last year, when the decentralized sales tax amendment, the renewal to put that on the ballot, had failed in the legislature. Some of the local government associations in Louisiana have taken the position that, really it's up to the state lawmakers to fix the system because, there are certain local exemptions that are outlined in statute or, optional taxes. They're just, the state has the ability to simplify some of the tax base for the local governments through statute. And some of them are even in the Constitution, some of the local exceptions. And so the local governments say this is really, it doesn't matter who collects it, it's going to be complicated unless, the state simplifies the different tax bases and exceptions. So that's one argument that they're making down there as well.
Yeah. Well, we have the opposite, really, where we have Colorado's like 81 exemptions and the cities don't agree with them. So we don't have a universal manufacturing exemptions. The city's tax SAS and the state doesn't. That's not an exemption. That's just not a taxable product or service. So we have a lot of disparities, but it kind of goes the opposite way where we have more exemptions at the state level that the cities don't have overridden because they have home rule authority and the states are easier to lobby. So it's easier to get a state exemption enacted than to get each little city because you're not in every little city. There's 70 in Colorado that are home rule. So yeah, it's very interesting how we've given this authority to the locals, which I appreciate why they need it. I appreciate why our states need authority because the federal government doesn't give them enough money, but it does create a lot of complexity in tax compliance. So, and the voluntary system that we have.
Well, and Judy, you saw, right, and call my bluff if I'm misspeaking, is, we had the license fee issue in Colorado and where, all of the jurisdictions could say, you owe me $15 for a license fee because you sold into here, so you're doing business. But I think the state kind of overruled that. If you're not physically located in that jurisdiction, you can't impose like a license fee. And the state was able to get around that by a matter of what, statewide concern?
Statewide concern. So in order for Colorado to override a city authority or a county authority or any local authority, it has to be a matter of statewide concern. But there was a ton of jockeying that happened in the back room to get these cities to agree. I mean, we had multiple calls with different cities. Some cities were hard and fast. They were absolutely insistent on their registration fee. They needed it. They wanted the money. And other cities were like, we'd rather have more taxpayers and give up the fee. So we were split in our views on that. So it did ultimately have to come down to the state legislator overriding it. But there was a lot of agreement in the back end.
One of our reporters had written up a story on the amended complaint that Wayfair had filed against Lakewood just in the last week or so. And when you look at both Wayfair's case now and the Halstead Bead case, it does kind of, bring up the question of, to what extent, if any, do home rule jurisdictions, what are limitations on their authorities potentially, or what burdens can their varying local rules create for companies that just want to comply with the Wayfair decision? Certainly, as you mentioned, Colorado has the SUT system, and I think this complaint goes back just to before periods before Lakewood had joined. Maybe there's some overlap, but I think it kind of stops right when that happened. But it's an interesting case because since Wayfair came down and different practitioners we talked to and different tax conferences we've reported on, practitioners have raised the question as to whether or not Wayfair gave local governments the authority to also impose economic nexus for sales and use tax. And so, now this case, with Wayfair now against Lakewood, has the potential, I guess, to really kind of highlight those issues and kind of clarify, potentially have a court clarify, what Wayfair meant, if anything, for the local government authority and, when undue burdens may or may not exist. So that's really one issue that, it's kind of been percolating. We've heard people talk about it for a while. And, now this, with the Wayfair case being filed, a court may potentially have a chance to revisit that. And similar, Halstead Bead's a little different because it's, challenging the whole structure of Louisiana instead of just one city in itself. But tax practitioners there have said even the Halstead case could also kind of, further clarify Wayfair, follow up as to when, undue burdens are created. But I will say too, Adam Timish, a tax professor at the University of Nebraska College of Law, had said about Halstead Bead, he said, if he were designing a tax system, it wouldn't look like Louisiana's, but the question is, is that unconstitutional? And so I guess that's one thing that, courts are going to have to wrestle with. But with the Wayfair case renewal, some, observers believe it could be, one to kind of, further, clarify to what extent local governments have the authority for
I mean, all
to
three
kind
of
of
these
go along.
cases kind of are going to hit on good issues that it's simulated, might give some transparency to, taxing jurisdictions about how they can go about enforcing laws, and overriding or taking tax positions against taxpayers. So it's kind of an interesting ripple effect we're seeing all these years later. And now we're going to get more clarity with these cases, I hope.
Or just, hopefully clarity, but it could just even like muddy the waters even further, right?
Oh.
Well, because then there's how long are these going to take? And are you filing a bunch of protective claims? Kind of like, Philadelphia's got this potential kind of liability of $10 million on
people, right? And at some point that goes away. If you don't file those claims, that statute closes. So you got to get those out now and in the system, and they're just going to sit there and wait for that money to come to you if the state loses or the city loses. Yeah, no, that's an interesting point. So all that paperwork really to preserve your rights. And the government has spent the money. It's not like they didn't allocate it to something.
So then as we wrap up here, Paul, we've been talking pretty much kind of in the micro, focusing on some of like the city level stuff. So if we take a step back, what nationally kind of are you seeing any trends from a litigation perspective that just, I kind of have my viewpoints of what maybe, and maybe this is specific to like a training that I've read a bunch of cases on, but is there something that you're seeing kind of nationally trend wise that, common themes are being litigated?
I guess in this year alone, one of the common themes that come to mind is whole taxation of pass-through sales of interest in pass-through entities. There was the VAS Holdings case in Massachusetts, where a Supreme Judicial Court in Massachusetts, held that the state, it could have been constitutional for them to tax the interest from that a Florida corporation realized in selling a pass-through business, but the state law didn't permit it. In New York, there was Goldman Sachs case, New York City case, where they said that the city could tax a London-based Goldman Sachs unit for their sale in the city-based partnership interest. And there's one out in California too. I can never get the name right. I think it's Metropolis.
It's the Metropolis Family Trusts et al. Whatnot. Yep.
Sure. So, that's one thing that we've seen, just in the last few months, a spate of decisions about as to what extent states or localities can, tax sales of interest from entities that are based out of the state, but, they're selling something in an in-state presence. I think Professor Richard Pomp from Connecticut had said it's one of the hottest issues in, state tax litigation at the moment. And certainly there's a lot of money at stake in some of these cases too. So.
No, exactly. And they're saying you have nexus, you filed a return there, you made money there, you were doing business there. And now when you made a gain, we get a piece of it. Anyway, thank you for being here with us today.
Yes, thank you. No, I really enjoyed it. And thank you for having me.
Well, this has been Saltivation. Until next time. This podcast is for educational purposes only and is not intended, nor should it be relied upon as legal, tax, accounting, or investment advice. You should consult with a competent professional to discuss specifics of your situation and the applicability of the information presented.